Good evening and welcome everyone to the CJC today with your co-hosts, Edward Woods III and Christian Josiah, Chief Operating Officer, also known as Vice President of Administration, but more importantly to us, the Public Affairs and Religious Liberty Director for the Central States Conference and the Conscience and Justice Council Chairperson. Conscience and Justice Council Secretary is Josiah, and I'm happy to be here with you. We're here to talk about Adventist Pioneers and affirmative action. Just so you know, when we talk about Adventist Pioneers, we're not talking about it from a doctrinal standpoint, but the voices of our pioneers when it comes to dealing with the oppressed. So you'll get a little bit of education of the history of our church and our pioneers. And we're going to discuss whether or not we have veered away, are still on course as relates to our pioneers, and then also talking about affirmative action in light of the Supreme Court ruling. As always, we want to be current and relevant, and full of integrity, and we've assembled an all-star panel to help us, but once again, just happy to have my partner in crime, none other than the Right Reverend Dr. Bishop Pastor C. Jay.
Man, I tell you what, boy, if I was running for president, brother, you would be my manager. But man, it's good to have you, Elder Woods, on. Elder Woods is our chairperson. He's our fearless leader for the Conscience and Justice Council. And we are grateful to have this conversation. He also serves as the Public Affairs and Religious Liberties Director for the Great Mother Conference in the regional work, the Lake Region Conference headquarters in Chicago, Illinois. And we're grateful to have you guys on. Listen, man, what we need for you to do, as my good friend, Pastor Deblair Snell always says, Breath of Life, you know, we need you to be a digital disciple, electronic evangelist, and go ahead and share this link. This is going to be a powerful and important conversation as we, I don't want to say the word react, but we talk about what we witnessed just this week in the Supreme Court of the United States of America, some decisions that were made, in particular, the one on affirmative action. And man, so we need for you to share the link. If you're watching on YouTube, share it. If you're watching on Facebook, go ahead and share that link so that others can join us. Dr. Woods, you want me to go ahead and say a word of prayer and let's get started?
Get started.
All right, let's say a word of prayer, everybody. Father God, in the name of Jesus, Lord, we thank you even now, Lord, for allowing us to be in this space. We ask that your Holy Spirit will guide us and give us direction and understanding, Lord. Open up our minds, Lord, that we may be receptive to your spirit, to see and listen to whatever you would have us to listen to, Lord. I pray that you will be with the panelists who are about to come on, Lord. Give them clarity, but give them power, Lord, and may our hearts and our minds be open to the leading of your Holy Spirit so that we can make a difference and brighten the corner wherever we are. We ask these mercies in the name of Jesus. We pray that all God's children said amen and amen. I'm going to turn it back over to Elder Woods so that he can give an introduction to our five stellar panelists who are on with us today.
All right. Thank you so much. We have five all-star panelists. We're going to bring them on one by one before we get into a group discussion. As always, we will answer your questions. We're not running away from anything. We're not dodging anything. So if you have questions, please put them in the chat after you hear from our five panelists. Each of our five panelists will give a different perspective on Adventist pioneers and affirmative action, and you will hear from them in their own way, and then we'll come together, and we might have a few questions between Pastor CJ and myself, and then we will open it up for questions and an answering session as always. First to come up is none other than Dr. Jason O'Rourke. He is the Director of Mission Integration at the Littleton Hospital in Colorado. He is a licensed minister of the Seventh-day Adventist Church, an ordained minister, and we are happy to have him with us today to talk about the Adventist Pioneers. And the reason why we want you to know a little bit about the Adventist Pioneers, as you know, our church was formed during the Civil War here in the United States, and just want you to kind of hear the tone of the leadership at that time at the General Conference, and the strident messages that were coming from the pulpit, and seeing whether or not are we still reminiscent of our leaders, or have we gone astray as we talk about this very important discussion. So without further ado, Dr. Jason O'Rourke, take it away.
All right, thank you. Can you hear me well? All right. The Adventist Pioneers were originally, and this is coming from Dr. Kevin Burton. Dr. Kevin Burton has done some significant work, and in his work, he states that there would be no Adventism if there had been no abolitionists. The Millerites were staunch abolitionists, and here's a classic illustration of what I mean. When Joseph Bates, who was an abolitionist, began to believe, and this can be found, I believe, in Ellen White and Social Justice, that is published by Oakwood. When Joseph Bates had agreed, Jesus is coming, what ends up happening is he says, Jesus is coming, I must be ready to meet him, and I must work against racism. So for the early pioneers, and I'm just using that anecdotally, for the early pioneers, they understood that the issue of racism was intimately tied to the second coming, to the degree that no racist or slave approver could join their church. It was not possible. The publisher for the racial justice abolitionist paperwork, their paper that got put out, the publisher for that was the same publisher for the Millerite paperwork. And at some point, Joshua Himes took over the publishing work for both the Millerite paperwork and the abolitionist movement. These people were nowhere near the South, but they understood that they had a divine mandate from God. This is what it was. They understood that they had a divine mandate from God in preparing a people to meet him, meant also actively engaging in corrective justice within society. So Joseph Bates was one of the key people that helped with the desegregation of travel in Massachusetts. He and his wife were very instrumental in that, and other early pioneers. The church is founded in the center of the Civil War. And I remember Dr. Benjamin Baker had said that Adventism kind of grew up with Black people. Okay, now why am I choosing Black people? Because that is the issue around the time, and the issue of affirmative action is an issue of corrective social justice. You're trying to correct a social ill. And so what ends up happening is that after the Civil War, we have Reconstruction, and Adventists are sending people down south trying to do corrective actions. That they're trying to do education. Ellen White says we should do health, we should give health care and preach the gospel. Those were three big ones that Ben Baker states that Ellen White was very, very clear on. If you could not repay with finance, you could repay in these ways. The nation could repay. And yet they kept running into the peculiarity of the South, which was racism and segregation. They kept running into this. And so Kesia Renee Bennett wrote her paper. And when she wrote her paper, she says that Adventism initially resisted. We initially resisted segregation and racism. And then violence began to take place. Violence took place. And so what happens with the violence is that we begin to accommodate for the sake of personal safety. Okay, we begin to accommodate for the sake of personal safety to the point that it becomes institutionalized. What do I mean? What a lot of people don't understand is that health, education, and preaching of the gospel, the early Black preachers that joined the church understood that those three things could economically and educationally lift up the people that had just been freed. Mind you, that the nation had already given restitution to slave owners. They had not given restitution to former slaves. And so in this case, the Black Adventists and A.T. Jones understood that the doctrine of righteousness by faith was not just simply a spiritual, intangible reality, but if I am justified by faith, I must behave and relate to other people by faith, and that would have tangible manifestations in the life of Black people. Well, in 1888, they rejected the doctrine of righteousness by faith. And what we've been told is that it was on a notion of cheap grace. We didn't want cheap grace. Well, that's partially true, but that's not entirely true. Because prior to 1888, they've been baptizing Southerners. And when you baptize Southerners and you baptize them and you don't demand that they cease to be racists, and you don't demand that they cease segregation, that they cease treating these people as less than, when you don't demand that from them, then you accommodate and you swallow it. So when they rejected righteousness by faith theologically, they also rejected righteousness by faith practically. That was the other reason, because they just could not see themselves as being equal in any aspect in the church to Black people. So the same when A.T. Jones was the editor, the same Review and Herald that when A.T. Jones was editor excoriated the nation, and they would call the nation to task without reservation, not on political points. They would call the nation to task on strictly theological points. They advocated abolition and equality on strictly theological points, not on political points. They voted on theological points. They didn't have a party. They were nonpartisan. They were voting for what was theologically right. They were advocating for what is theologically right. Okay? They understood, they believed, and William Miller preached this. He was the first white minister, according to Kevin Burton, to preach this. He said, William Miller said that, and he quoted black preachers. He said that that God was going to pour out the 7 last plagues on the nation, just like he had the 10 plagues on Egypt for the sin of slavery. They understood and they believed that slavery and racism would usher in the second coming. They believed this. So when A.T. Jones is the editor of the Review, and Ellen White has finished writing her paper's message, Our Duty to the Colored People, and then she gets exiled to Australia. A.T. Jones is still the editor, and he is excoriating America in no uncertain terms for materialism, individualism, and industrialism. And what ends up happening is that that same article, that same publication, when the early 1900s excoriated America, come the 1970s, 1960s, 1950s, under Frank Nichols, they turn around and tell everybody, particularly ministers, if you participate in the if you participate in civil rights, you are in apostasy. That is what they say. So we swallowed the thing hook, line, and sinker. And so our entire 20th century of ministry, and this is demonstrable, of ministry has been irrelevant to current, present truth issues. We have spoken future truth about what the beast will be, or we've spoken past truth about what the beast has done. But we in the 20th century have not said this is the beast. In fact, we've babied it. We've infantiled it. We call it a lamb-like beast. Revelation doesn't say that beast is a lamb. It says it has 2 horns like a lamb. It doesn't say that the beast looks like a lamb. The horns are lamb-like. We've made this thing into something docile so that we can be cool with evangelicals and cool with the FBI and the Fed. And so our relevance, listen, you can watch it, look at it. Our relevance. Look at the state conferences. They are entirely irrelevant to their people. They ain't had significant baptisms in when? Totally irrelevant. My entire generation in the state conferences is utterly gone. Utterly. Look at the black conferences. Are we relevant to our people? Or are we following the state conferences in methodology and in vision and emphasis? Have we been doing that? Our founders, and all the way, there were people that were advocating. And somewhere and around the 1819s, Kevin Burton documents, we got a visit. And we changed because we didn't want to be in bad with the state. And we didn't want to be in bad with evangelicals. So we stopped being a cult. We stopped being considered communists. And we became part of the majority. And we became irrelevant This is how irrelevant we will be. We were, and I close with this. In South Africa, when the Dutch and the Boers are rancidly racist, and we allowed it because we had it over here. Rancidly racist. The Catholic Church is known for being the advocate for justice and liberation. When apartheid fell, Mark Finley goes over there to do messages. He goes into this big church to do messages. And of all the churches that were known for doing nothing, Adventists are known for doing zero. And what's your friend? What's the guy's name? Nelson Mandela. They invited Mandela to come to the meetings. He said he will never set foot in an Adventist church because we did not engage in the struggle of liberation, because our silence and passivity made us recipients, if not participants, of injustice. I'm done.
Mercy. Lord, have mercy on us. Have mercy, man. That was a word, Doc. That was a word, man. And we are living in a time, man, where we are trying our best to be relevant. We have to push back hard on that integration piece. Dr. Woods, Ed, what do you thought of what you just heard, man?
Well, as always, Dr. Jason doesn't pull any punches and is not afraid to speak truth to power with regards to what's going on. And it's interesting because Josh and Ashley, in their book, Church Refugees, and it talks about the millennial and Generation X, the two issues that they have with us is trust and relevancy. And it's not a white thing or a black thing. It's a Christian thing. And, the demographics are very clear. We're either believers or non-believers. Paul's very clear when it states that. But the trust and relevancy is a problem regardless of the denomination. And we have to go back to being relevant to our community. Amen. And when we talk about the Black church, we're not talking about a colored church. We're talking about the mission. And the mission of the Black church has always been being engaged in our community and accepting of everyone. Yes. People get kicked out of their church because they call them Negro lovers for the sake of the show. And they're not welcome in their church, but the Black church welcomes them. So we have to remember our roots, because this is a sterling call of the Black church, because we've gotten away from our mission, trying to be like everyone else instead of being true to the core of our community. So I want to thank Dr. O'Rourke for that, setting the stage as it relates to Adventist Pioneers. But now we got to get to the affirmative action piece and the history of affirmative action and how it got started. And I am just so excited that we have a very distinguished woman in her own right who is here with us, and none other than Dr. Linda L. Ammons. She did a tremendous job on our wealth show. She is a dean emeritus. She was at the Marshall School in Cleveland and another law school in Las Vegas. She's brilliant. She's also a minister of music. So she's going to say it. Jason wouldn't sing for us. He just gave it to us. He poured out the wrath. But Dr. Ammons might give us a little song as she speaks truth to power. But we'll let her come in her own way. So Dr. Ammons, thank you so much for being with us. And we look forward to you giving us the history of affirmative action and how it came to be, so people have a clear definition and not try to change the narrative. Thank you.
Well, good evening, everyone from coast to coast. Thank you for inviting me to participate this afternoon. And let me just tell you in just a couple of words what we're going to do for the next 2-3 minutes. I'm going to talk about the history of affirmative action. It's going to be very quick. Then I want to talk a bit about the notion of colorblindness, but I really want to get to this opinion that was passed down this week, and particularly the majority opinion. I know most of you don't do that in terms of reading the 264 pages, but and I can't admit to have read every page, but I've read enough to know what's going on. So let's get started. You may not realize this, but affirmative action began as far back as 1935 with the Wagner Act, which was a New Deal law that dealt with the organization of labor unions. That's where the term comes from. And then it gave workers the right to organize. And then in 1961, President John F. Kennedy signed Executive Order 10925, which dealt with provisions in government contracts, and said that it was his policy, and he was the first president to do so, that wanted to advance racial equality in terms of contracting. He created a committee on equal employment opportunity, which used the term affirmative action to refer to measures designed to achieve equality. That's where it began. And then in 1965, LBJ, Lyndon Baines Johnson, issued Executive Order 1124 dealing with employment again, and he prohibited those who were receiving federal contracts or subcontracts from engaging in discrimination. That same year, President Johnson spoke at the Howard University graduation, and this is what he said. Laws prohibiting discrimination are not enough, and there needs to be more proactive measures, and they are necessary. You do not wipe away the scars of centuries by saying, now you are free to go where you want, do as you desire, and choose the leaders you please. You do not take a man for years who has been hobbled by chains, liberate him, lead him to the starting line of a race, saying you are free to compete with all the others, and still justly believe that you have been completely fair. I'm going to truncate some of this. Then he said, we seek not just freedom, but opportunity. Not just equality and right, but equality as a fact and as a result. That was in 1965. If I could jump back just a little bit to 1896, this notion of color blindness comes out of dissent in the case of Plessy v. Ferguson. From history, you may remember that case. That was the case where separate but equal was established. Jim Crow was nationalized as a result of that case. That was the case that came out of New Orleans, where a very fair-skinned African American sought to ride in the train car, and he was told that he had to go to the back where the rest of the coloreds were, and that case went all the way up. The notion of colorblindness comes out of the dissent by Justice John Marshall Harlan, who said this: in the eyes of the law, there is no superior, dominant, ruling class of citizens. There is no caste here. Our Constitution is colorblind and neither knows or leaves classes among citizens. In respect to civil rights, all citizens are equal before the law. That's where that language, that notion came from, which has now been turned on its head. Let me get to the case of this week. I categorize this case as one of the most ignorant cases that the United States Supreme Court has ever written in terms of the majority opinion. And I call it ignorant, not to be pejorative or using hyperbole, but the root word for ignorant is ignorare. It is also the root word for ignore. And in the majority opinion, the majority ignored or disregarded, which means the same thing, that Latin antecedent. They ignored the precedent. They ignored their own standards of review. They ignored the lower court's fact-finding. They ignored history, and among other things, they ignored logic and common sense. Just to give one example of what I found to be quite disturbing, and you can find this in the dissent, in Sotomayor's dissent. She talks about the fact that the schools, University of North Carolina and Harvard, had dozens of fact witnesses, expert testimony, and documentary evidence to present to the court to show that they were not discriminating against anyone. And the other side, the side that won, had two, count them, two experts. Let me walk you back through just a little history of how we got to where we are. It seems like discrimination in education has followed me all my life. I was born when Brown v. versus Board of Education was argued the first time. And it seems to have followed me all my life. But let's talk about more recent cases. So you have Brown in 1954 that says separate is not equal. Then in 1978, you have the Bakke case. I remember the Bakke case because I was in graduate school at the time, and we were all concerned as graduate students about what that was going to do to our education. In Bakke, for those of you who don't remember, there was a white student who wanted to be a doctor, and he wanted to get in medical school at the University of California at Davis. And he sued California, saying that he was being discriminated against because black people got in and he didn't. That was the basis of his argument. Well, in that particular case, Justice Powell, who was on the bench at the time, said that as long as there was compelling state interest and this interest was narrowly tailored, which is the test for constitutional equal protection, the 14th Amendment. It requires that if you're going to treat somebody differently, number one, the state has to have a compelling interest, and number two, that whatever it is that you're going to do has to be narrowly tailored. So Bakke got rid of quotas, but it upheld the notion that diversity was a compelling interest, and that with some tinkering, it could be narrowly tailored. Then in 2003, the Grutter case came down. In 2003, I was busy as an associate dean dealing with admissions, and in this particular case, the Michigan Law School was sued. And in that case, Justice O'Connor talks about the fact that there's a need for a critical mass, and the short of it is that Grutter was found that there was a compelling state interest in how Michigan took care of its business. In more recently, we've had the Fisher case, and in that particular case, the court said that there could be a limited use of race. And then we come to the case that the court handed down this past week. Justice Sotomayor said this about this, and what the overriding issue is this: what does the 14th Amendment of the U.S. Constitution mean? And if you read Sotomayor's opinion, the very beginning part, you see how she lays out how the 14th Amendment, the 13th, 14th, and 15th Amendments were written specifically to provide a remedy for injustices. With these cases, beginning with Bakke, you see the notion of remedy receding to the background and notions of diversity taking the foreground, and then it is just chiseled away. But she says this in terms of what the 14th Amendment means, quote, "The court concludes that indifference to race is the only constitutionally permissible means to achieve racial equality in college admissions." So, she also says, ignoring race will not equalize a society that is racially unequal. What was true in the 1860s and 1954 is true today. Someone else wanted to make some comment on Justice Jackson's opinion, so I'll leave that to them. And any other remarks, because I think I'm out of time, I will try to work in as we continue this discussion.
That's good. That's good. That's good. We appreciate that. One thing you said just now, that the state has to have a compelling interest. Is that right? Is that what I heard?
That's right. If you're going to treat similar people differently, the state has to have a compelling interest.
and it sounds like, and I know we're gonna get into questions a little bit later, Dr. Woods, but it sounds like the Supreme Court, based on what you said, they ignored. That's where the word ignorant comes from, and disregarded this kind of precedence. Now, and we're gonna get to the prophetic and why we believe that this is something that we would have seen, and that we shouldn't be surprised about, but it still hurts when you see. We're going to get to that with attorney Tim Golden, but that was some compelling stuff. So I'm gonna turn it over to Edward Woods the third. Go ahead and take us forward.
Well, Dr. Evans, as usual, Linda, you have not
Mercy.
disappointed.
Yeah.
you have taken that 200 and something and broke it down. But that rich history of affirmative action, if you missed it, I want to encourage you to go back and listen to how affirmative action, and so many people thought it started in the 60s or the 70s, but Dr. Linda traced it back to the labor movement in the 30s. So go back and listen, because so many times we repeat what we hear. And I want to say that because I was at an event in Lake Union Conference several years ago, and they repeated what they heard, where they heard that the only reason why we have regional conferences is because we wouldn't give up drums. And that is a myth of mammoth proportions, because they have repeated what they've heard instead of researching for themselves. So I want to encourage you to go back and do the research and be an informed opinion. There's no need for you to repeat MSNBC or Fox News or CNN. Repeat the facts because you took the time to research for yourself. Dr. Evans, thank you for reminding us of that fact and being with us today.
Welcome.
I'm so excited to have our next guest with us today. She is brilliant. I just got to tell you, she's brilliant. I've enjoyed watching her matriculate, and she has goals, and she reaches her goals. Whether it's a barrister, she's going to reach her goal. A lawyer, she's going to reach her goal. Starting her own business, she's going to reach her goal. You can tell her no, and she will always get to yes. From the movement, from the city lawyer is what she is. And if you just look at her, she is just, I'm so happy about this girl. I just love her for her. She knows I love her dad, but I love her for her. And Nia, we are very happy, Esquire, to have you on here this evening. And we want to make sure, I want to repeat, we want to make sure that we give you your time in doing this analysis. But thank you so much for being with us today. And we just, for all those people who want to be a lawyer, Nia is a role model right now for what greatness looks like, not in the past, not in the future, but today. So welcome to the broadcast. We look forward to your analysis and the opinion that you share as it relates to the decision that the court made.
Thank you. Thank you for having me and for your kind words. So basically the background of this case is that an organization called the Students for Fair Admissions filed suit against Harvard and the University of North Carolina, accusing the schools of using race in a way that depressed artificially Asian American admittees into the school. Specifically for Harvard and at UNC, it was something that negatively affected Asian and white applicants to the school. And so they filed suit saying that their rights under the Equal Protection Clause of the 14th Amendment and Title VII prohibited that, and that they weren't being treated equally under the law. In the opinion that just came down this week, the Chief Justice wrote that the Equal Protection Clause applies to everyone because it doesn't, in the text, regard the differences of race or nationality or other differences that could arise, like your color. And so it has to apply to everyone. And he said that eliminating racial discrimination means eliminating all of it. And so we had to guarantee equal protection by not letting some things apply to some individuals and not to others. That ruling that the admission practices of Harvard and UNC violate the Equal Protection Clause of the Constitution is just wrong and just historically inaccurate. It makes it seem, the arguments that have been coming up into this case has been, a version of this case has always happened. People have been challenging race-conscious affirmative action for years. And they always describe race-conscious affirmative action as something that guarantees that Racialized and ethnic minorities in this country are going to get a certain result when they apply to higher education, particularly like Ivy Leagues and well-known schools. And so it's very dishonest. It's a very dishonest opinion, historically inaccurate and presently inaccurate opinion. I just have some notes here that for me to say that now is like the time to end race-conscious policies and practices is just not right. UNC, one of the schools that was being sued against, is the oldest public university in this country. It opened in the 1780s, and it didn't admit Black students for over 200 years. And the only reason why the school admitted Black students was because they were forced to by court order. Similar stories for Harvard. It was founded in the 1600s, didn't admit its first Black student for over 200 years. Right now, Black students, and there are other types of racial and ethnic minorities, but Black students only make up about 6.6% of students at Harvard, 6.5 at Yale, 7% at Brown, Princeton, 4.7, Columbia, 5.1, Cornell, 5%. And considering race as one of many factors in a holistic admissions process has been upheld by the Supreme Court with, unequivocally for 45 years. A version of this case has come up before the court many times, and they have continued to uphold until this last decision that race is fine to be considered as one of many factors. It's not a factor that gives, Black and Latino and other students a huge advantage over white students. It's not something that happens that way. And also this opinion and the cases that brought it to the court, it's not going to be a net positive for Asian American and Asian applicants either. In fact, it will particularly hurt South Asians and just brown Asians in general. That's going to be something that's not going to be a positive for them. So again, to prohibit schools, but not military schools, for a reason that's odd and doesn't make sense, but is true according to the majority opinion, from considering race has devastating consequences. For example, in 1996, California had a referendum and prohibited the University of California systems and other state entities from considering race, gender, and ethnicity in their application process. Immediately after that, only one Black student was enrolled at the UC Berkeley Law School immediately after. And as years have gone on, there has been some other diversity, economic diversity, for example, that has been improved in the UC system. However, the racial diversity still today in the UC system is not reflective of the racial diversity of the state of California. So even though race is one of many factors in a holistic process, it is not getting rid of that one thing in a holistic process does have devastating consequences. And so this is like a very terrible opinion. It doesn't make sense. They got the law wrong on purpose. And it's just, for me personally, Dr. Linda was talking about the history of affirmative action, and I thank her for laying out that history. But even thinking about the purpose of the 14th Amendment, I'd say that the affirmative action really started in the 1860s. The 14th Amendment is a Reconstruction Amendment. It was passed and ratified specifically for the purpose of people, the country, being able to pass laws that would address and redress the legacies of slavery and racism, so that people who had been historically kept out of certain areas, social areas in life, other types of areas in life, would be able to, via these laws that were passed after the ratification of the 14th Amendment, be able to have access. This isn't a thing that, puts unqualified people in a place that they don't belong. It isn't a thing that, is purposely excluding white people. But the 14th Amendment, and specifically the Equal Protection Clause, was not something that was crafted to help white people, mediocre or otherwise. It was something to bring in people who were historically kept out into spaces. Again, not people who weren't qualified for those spaces, but stuff that affirmatively pulls in people that others wouldn't have known about, others wouldn't have even considered before. And so this is a very devastating opinion with more consequences than we can realize, or not that we can realize, but more consequences that are on its face right now. This will not only hurt how we work in schools, but this will have impacts in our businesses. This will have impacts beyond higher education. And I'm sure others will speak to that later. So I will end there. But yeah, thank you.
Wow. Thank you. Thank you. That was a lesson right there. You mentioned something, attorney, about, you said 6.6% at Harvard were Black right now. And I know Edward Woods III, our co-host, shared a podcast where he talked about legacy students, athletes, students of donors, and those percentages are way higher than the 6%. And so you sound like you don't see this thing helping us any at all.
Exactly. They're fine. The Supreme Court seems to be fine with that type of affirmative action, the affirmative action with the legacy students or other students that are able to be have diversity in another way. For whatever reason, race affirmative action is not okay. But affirmative action for people who can afford to go there, whose parents went there, and generations of people went there, that affirmative action is okay with this court.
Mercy.
Attorney Nia, talk to me, Esquire, about Southern Asians. You mentioned, they keep talking about Asians holistically, but you mentioned the impact on Southern Asians. Can you kind of elaborate on that in terms of the countries? Because there's an assumption, usually we talk about Asians, people think about Japanese, Chinese, and Koreans, and they stop.
Sure. I think, well, generally all the Asian Americans that I know are for affirmative action. But as this opinion has come down and as the case has been coming up even before the opinion was released earlier this week, this is not a net positive for all of Asian Americans. Brown Asians, like Southern Asians, they're going to be disadvantaged by this. Other groups are just going to be disadvantaged by this. And so, yes, when we think about Asia, we have to think about Pan-Asia. It's not just East Asians. And that's an important thing to consider as we think about who's being helped and who's being harmed by this. And also, even East Asians generally are not going to be helped by this in the way that those who are against affirmative action in the race sense think.
Mercy.
It's interesting because when we talked about COVID-19, and the vitriol to Asians was horrific as related to COVID-19, and they were known as the model minority, but that model minority stigma kind of wore off because they were being blamed for bringing the COVID-19 virus here. So this is another, reality check that the discrimination is real for all Asian Americans, maybe not just the top three, but all Asian Americans. All right, we want to thank you. We want to thank Nia Langley Esquire for those comments. Once again, we want to thank her for those comments and insightful analysis that she shared with us. The movement lawyer, I repeat, the movement lawyer for Bread for the City. It's now our privilege and honor to bring up the professor in his own right, in his, I like to call his stellar career, a man full of wisdom and is very helpful to students and has really been instrumental in bringing the history and political science to relevance at Oakwood University. A distinguished gentleman in his own right, none other than Professor Preston Foster.
Woody, thank you so much. It's great to be here. I think the best thing that I could say right now is that Nia Langley was my student. I'll be bragging about that for the rest of my career. So I'm so proud of her, but I have so many expectations that she soon will be sitting next to Justice Jackson, and I'm very serious about that. I want to offer just a little political analysis. As a pragmatist, I like to kind of ground us in what does this really mean? What is the so what of this? And I'm going to preface my remarks by saying this. I am an affirmative action baby. My career started with AT&T. I was hired into AT&T out of Oakwood because of affirmative action. I had the opportunity to attend Harvard University because of affirmative action. I am, unlike Justice Thomas, pro-affirmative action. But what I want to say may be a different take from what most people may think or react to. From my reading, and I'm not an attorney, but I did read Chief Justice Roberts' opinion. And in my opinion, politically, I think they are embarrassed by their decision. So much so, and by that I mean, at Oakwood, we help probably 20 to 30 students write their personal statements to law school.
Oh no, ladies and gentlemen, we're having technical difficulties with Dr. Foster, and so sit tight. We really need this commentary from him. He went straight. He went straight to the Chief Justice's opinion, and so just sit tight, everybody. Or we may need to go to our next panelist. So I'm gonna let my co-host help me decide what he wants us to do as we try to get Dr. Foster back. I'll tell you what, at this time, yes. All right, we've got Dr. Tim Golden, my Eagles buddy, on the line, and I know he's ready to go. Edward Woods III, you want to go ahead and introduce him? I know you sweating over there. It's okay, man. Just breathe. Just breathe.
It's still the Sabbath, so we're just gonna keep it holy.
I know.
But I know y'all gonna say, "They that wait upon the Lord shall renew their strength. They shall mount up on wings like eagles. They shall run and not be weary. They shall walk and not faint." But we are happy to have one of our friends for the Conscience and Justice Council, brilliant in his own right. A man who tells stories. He tells stories for a living. And we're just very happy once again to have someone of the caliber of Dr. Timothy Golden, who holds a PhD in philosophy and a Juris Doctorate degree. He is a one-man soliloquy as relates to Thurgood Marshall, and he is an actor. He's an activist. He's an attorney, and he's someone that is astute. Yes. And always willing to share his acumen on these types of subjects. So without further ado, ladies and gentlemen, let's listen to Dr. Timothy Golden as he comes from the book of Revelation and putting this affirmative action ruling into light, not just prophetically, but also practically and relevant as relates to July 1st, 2023.
Thank you, Elder Woods.
No, you guys don't want to hear from me. You don't want to hear from me. So let's get Dr. Tim Golden back. There we go.
Thank you both for inviting me here, and it's an honor to be here with such a distinguished panel. I certainly hope that we are able to get Professor Foster back as soon as possible. I was settling in for what I'm sure was going to be an outstanding commentary. That said, I want to devote my remarks on this significant decision this week, significant but ultimately, I think, injurious decision from Thursday. And in order to do that, I want to talk about the theological part toward the end of my remarks. But I want to begin with an analysis of what I believe is a phony method of constitutional interpretation. And that phony method of constitutional interpretation that I want to try to unpack in the next few minutes is originalism. Originalism has its genesis in political ideology, specifically after President Reagan won a landslide re-election in the 1984 presidential election. He decided that he wanted to remake the federal judiciary in the image of American conservative politics. And so his attorney general, Edwin Meese, 38 years ago, in a speech in 1985, I believe it was in June of 1985, on the heels of that landslide victory. By the way, just to put this in context, President Reagan won the 1984 presidential election by an electoral count of 525 to 64. Think about that. 525 to 64. So that's a mandate. And on the heels of that mandate, what is happening is that Ed Meese says in a speech that it's time to appoint judges to the federal judiciary, including the Supreme Court, who have a, quote, original understanding of the Constitution. And it was from that point forward that this doctrine, so-called doctrine of originalism, begins to pick up steam. Now, remember, it originated not in some transcendent realm of a priori legal validity, but rather in a political speech by a conservative attorney general, part of an administration bent on reshaping the federal judiciary into what he thought was a conservative reflection of his own values. And I really like what attorney Nia Langley had to say a few moments ago, because she was moving in a direction that makes the very basic point that the 14th Amendment was ratified as a means of enacting race conscious policies for the sake of remediation. In other words, the 14th Amendment, in its original understanding, is about affirmative action. Now, or I should say, even I dare say, is an element of affirmative action. But only in the United States could the original understanding, and by the way, that's what originalism is supposed to be. Originalism is supposed to be a method of constitutional interpretation that interprets the Constitution in a manner consistent with what the meaning was at the time the provision was adopted. And if Attorney Langley is correct, and indeed I believe she is correct in her description of it as an adoption of a means for a race conscious, for having and legitimizing race conscious policies as remedial corrective measures for injustice, then yesterday's decision, according to the originalists who supposedly wrote the majority, would be a 180 from what it turned out to be. So originalism, it seems, only applies in contexts in which conservative political ideology is adhered to by just enough of the justices to get a majority, and then we'll dispense with originalism as we so choose. That is not a legitimate means of constitutional interpretation. Instead, what it is actually is a political ideology masquerading as a transcendent legal principle that is used selectively, and in this case, to further the oppression of Black people in the United States. That's only in America could an amendment that was intended on liberation become an amendment that could be used to oppress. And that's exactly what the Supreme Court's interpretation does. Now, in that context, I want to talk about the majority's completely ignorant view, and if I can use the word ignorant in the sense in which Dean Ammons used it in her remarks, completely overlooks a history that Justice Ketanji Brown Jackson so brilliantly exegetes in her dissenting opinion. You know, conservative legal scholars are fond of quoting Justice Harlan's dissenting opinion in Plessy versus Ferguson to bolster some bogus notion of colorblindness. But few of them, very few of them, quote his dissenting opinion in the civil rights cases in 1883. And in that decision, the civil rights cases in 1883, the Supreme Court struck down Congress's attempts to enforce the 13th, 14th, and 15th Amendments. And in doing so, what the majority said in the civil rights cases decision was, at some point, the Negro has to be a free person and has to cease to be a ward of the state. But I want to quote, as Justice Ketanji Brown Jackson did, from Justice Harlan's dissenting opinion, not in Plessy versus Ferguson, not in the opinion that conservative legal scholars pimp, and yes, I use the word pimp, and take out of context in service of an agenda in a bogus notion of colorblindness, but rather to give the full flavor of who Justice Harlan actually was when it came to these cases. In the civil rights cases in dissent, Justice Harlan responds to the majority who said the Negro has to at some point cease to be a ward of the state and the special favorite of the laws. He said this, quote, "What the nation through Congress has sought to accomplish in reference to Black people is what had already been done in every state of the Union for the white race, to secure and protect rights belonging to them as free men and citizens, nothing more." That's the Justice Harlan that conservative legal scholars refuse to quote. And just to put that in context, the civil rights cases decision in 1883 ultimately invalidated two acts of Congress that would have done in the 19th century what the Civil Rights Act of 1964 eventually would do nearly 100 years later, and Jim Crow, and segregation and public accommodation, and hold private persons accountable for acts of discrimination based on race. And so I want to just very briefly now talk about the importance of Justice Jackson's dissenting opinion as it relates to Christian theology. And I'm very intentional about this because the majority opinion ignores history. Justice Jackson's opinion is attentive to history. And if we are to be Christians, in particular, if we are to be Christians in the prophetic sense, we must understand that the central feature of the Christian gospel is a God who is attentive to history, is a God who is so attentive to history that he enters it in order to save us. A God who is so attentive to history that there would be no salvation, there would be no deliverance except the God of heaven intervened in the person of Jesus Christ to deliver his people. And it didn't just happen through the birth through his birth through a virgin. It happened in the book of Daniel when the king said, "Lo, I put 3 men in the furnace, and now I see 4, and the 4th is like the Son of God." From Genesis to Revelation, we see a God who is intensely interested in history. And if God is interested in history, and if his interest in history results in deliverance, and if we are made in his image, then we too must attend to history, because the failure to attend to history will always result in continued oppression. And Justice Jackson's dissenting opinion unfolds in close proximity to the history of Black people in this country. And it unfolds in such a way that if her view was the majority view, we wouldn't be sitting here today talking about the continued oppression of Black people. We instead would be talking about how the law's attentiveness to history results in deliverance. And so if you want to take a look at the book of Revelation, and I'm going to close with this. You take a look at the book of Revelation, and what do you see? You see what Dr. O'Rourke pointed to earlier in Revelation 13, a doctrine within the Seventh-day Adventist Church that speaks to a beast with lamb-like horns who would speak as a dragon. I want to share with you, Christian friends who are listening, that Revelation 13 does not refer to an event. It refers to a condition of this kingdom, such that there will always be a conflict between the gentility of its ideas and the harshness and oppressiveness of its speech, as indicated through its legislative and judicial pronouncements. And what we heard this past Thursday was the continuation of a condition of hypocrisy, a condition of oppression that will continue to plague us until the Lord brings an end to this madness when he returns. So if you want to talk to me about Christianity, if you want to talk to me about Christianity and race, you want to talk to me about the Christian gospel, you better come prepared to engage history, because we serve a God who's so interested in history that he entered it to save us. And when we ignore history, people end up dying, people continue in oppression, and sadly, that's the state of affairs in which we find ourselves right now. God have mercy on us, and I pray that we will have the strength to continue this fight until he comes again.
Lord have mercy. Got a friend of mine used to say, golly dang. Oh man. Wow. Thank you, Doc. I think you've dropped the real deal on us as far as the heart of God, and his how he views this thing, man, from a place of being intentional about intervening for those who have been oppressed, and the opposite of what we witnessed this week, not just in this case, but there's a few other cases that we didn't talk about, that the Supreme Court pretty much seems to be going backwards, because, and it almost feels like they just don't care about us. That's how it feels as a black man in America. Dr. Woods, go ahead. Or you might be muted.
Dr. Tim Golden brings a rich perspective, not just from the legal analysis, but also his acumen with regards to revelation, because we speak so much of revelation prophetically, but not practically, and apply it. And I really appreciate how he does it succinctly, convincingly, and with evidence, so that we can go back and study and research for ourselves. So thank you again, Dr. Golden, for your analysis and your perspective. And we're happy to report that Professor Foster is back with us, and we're looking forward to engaging him. We heard you loud and clear that you wanted to hear back from him
we heard him.
after we heard the stellar analysis from Dr. Golden. So many of you already know that Professor Foster is with the History and Political Science Department at Oakwood University. He has brought a resurgence and an interest in it, as you could tell earlier how proud he was of one of his students in Nia Langley, the movement lawyer with Bread for the City. And he's an all-around great guy, and we want him to have his time right now. Without further ado, Professor Foster.
Oh, well, thank you again, and I apologize. I'm kind of on a spotty internet connection today, so that's at least partially responsible for you losing me earlier. I did want to say one other thing about just the program at the public policy or political science program at Oakwood. We have purposely, since we've been in that position, added 2 classes that didn't exist in the curriculum before. One is political philosophy, but the most important class that we've added is a class called Church and State. And that class was added because we believe that the Adventist mission statement defines our reason for existence, our raison d'etre, as outlining to the world what this means prophetically and what it means in practical and political terms in the end times. And so Nia Langley and others are being weaponized, if you will, in a positive way, to stand on the wall to protect our religious liberty, and also to prophetically explain to those in power the reasons why religious people are for the separation of church and state. I'll quickly just move to the last point that I was making in my political analysis, and then I'll turn it back over, because I so much more enjoy listening to the panelists than I do speaking myself. And that is the point that underlying all of this breaking down of affirmative action presumes that merit is fair. Merit as defined by those who have been in power over the years. Merit as defined more specifically as performance on standardized tests. I spent 6 years of my career working for Educational Testing Service in Princeton, New Jersey. They are the people who write the test questions for the SAT. And so I was the public affairs and communications vice president for ETS for several years. And in that role, I came to understand the strength and the weakness of standardized tests. And I'll just tell you this one very simple anecdote. My real estate agent in Princeton, New Jersey, as you know, that's a fairly wealthy Tony neighborhood. She told me that she spent $20,000 preparing her son for the SAT test. And she described her own son as a, quote, near idiot. And the $20,000 that she spent preparing her son for the SAT test put him in the top 5% percentile of SAT scorers. So she knew that performing well on these so-called merit-based tests had more to do with specific investment than it did with any underlying intellectual skills or intellectual deficits. So this whole notion of deficits and African Americans not performing as well and being given a leg up is, to me, absurd, because as we know, African Americans, women, and other oppressed people in this country have to overcome more to be considered to be equal. So this underlying premise of merit is a specious argument at best. With that, I'll turn it back over to Dr. Woods and my other panelists. Thank you.
Professor Foster, before we go back, can you highlight your 3 points? Because we want to make sure everyone got them, and there's no excuse for why they didn't get what you shared with us so richly.
Well, first, my first point briefly was that it seems to me that the Supreme Court, Justice Roberts in particular, was embarrassed by this decision, in that the decision still allows for Blacks to identify themselves in their personal statements and essays and in other ways on their applications, and for that racial identification to be part of the consideration of their application. Secondly, I want to kind of warn against us as Blacks spending too much of our political capital defending affirmative action. One, we have HBCUs, and several of my former students, graduates of Georgetown and Harvard and American University, all tell me, again, if they had it to do over, they would go to Howard rather than Harvard, to go to somewhere where they are valued, where they don't have to defend themselves against assumptions of their presumed inferiority, et cetera. And really the benediction on that is that the trade-off in 1995 for defending affirmative action was that blacks, middle-class blacks, would have to sit on their hands when President Clinton signed the crime bill, which was the catalyst to mass incarceration. So what I'm saying is defending affirmative action cost millions of people years behind bars who should not have been there. It's not our fault. It was a false choice, but it was and is a real political choice. And then finally, again, I would just remind everyone that this decision ironically puts affirmative action on the back burner politically for Joe Biden and other Democrats, meaning that they can run for it on it in terms of saying to Black people and others who benefit from affirmative action, and ironically, again, white women benefit from affirmative action more than any other single group. But at any rate, it kind of is a case of the dog catching the bus, kind of like the Dobbs decision, where now opposition to abortion rights is a political negative, even in states like Minnesota and Kansas. So this decision, although injurious to us in the short run, may allow us to gain some political ground that allows us to balance this court out a little bit better. Thanks again.
That's pretty good stuff, man. That's pretty good stuff. There's a couple questions coming in.
Right, we do got a couple questions, but let's make sure we salute Professor Foster for sticking with us and his determination to work through the technology. And for those of you who were in our chat and blowing us up, we just want to make sure you respond, because one of the things that is important to us is having quality content on every CJC show, today's show that we do with regards to our panelists. So we're going to bring everyone back in, and then Dr. Josiah, you said you had there's some questions. I know you have questions, and so we'll let you go ahead and start with your questions, and then I'll bring up the questions from the chat.
Or I was going to say, for the sake of time, we can go straight to the chat, because I think one question that kept coming up repeatedly as we were scrolling through was, do you believe, and this is for any of the panelists, do you believe that the Supreme Court's decision to gut affirmative action will result in a surge in applications to HBCUs in America? And I see heads are nodding, but anybody can. It's a question that we saw repeatedly in the chat, so anyone can take a shot at that. Do you believe that this decision will result in a surge in applications to HBCUs? Anybody?
I don't know whether there'll be can you hear me?
Yes,
you hear
we're
me?
hearing you. Mm-hmm. Yep.
Yeah.
Okay. I don't know whether surge is the appropriate word in terms of application, but I will say through necessity, it as a result of this affirmative action case, more students will have to look at HBCUs, and that's not a bad thing. It's a good thing. I'm a graduate of an HBCU. But we have assessed what the current state of affairs is. I'm a bit more of a pragmatist. I want to know what the next step is. I don't know why this decision came, as if it did, as a surprise to anybody. This has been being worked on since 1978 at the earliest in terms of dismantling affirmative action. And those of us who are in the academy, we have the luxury of reading more closely and spending more time talking about it than the average person does. But if you go through, I gave you a list of cases and you read about it, each case, something is being chiseled away that brought us to this point. And I don't see why this came I would have been surprised had they not done it. I would have been absolutely surprised with the composition of the court as it is currently. And I also say I'm a little disagreement with one of the panelists in terms of the whole HBCU thing. Everybody can't go to an HBCU. And in addition to that, I don't think that we should ever give up what is rightfully ours. What has happened with affirmative action and some other issues as it relates to African Americans is the goalpost keeps being moved. And sometimes we perceive it and sometimes we don't see it. And this, I made mention of this early in my remarks. When we first started talking about affirmative action, we were talking about black folks and affirmative action. Then we started talking about minorities. Then we started talking about diversity. And with each iteration, we get further and further away from what this thing was designed to do. It is a remedy. Any other group in America that has been wronged has been able to have been presented, have been given options in terms of remedies. We have never gotten our remedy, and education is just one aspect that in terms of looking at it. So my question is, I guess my comment and question is, we need to be focused on what is next. We can't do anything about what has happened, but what is the next? How do we continue for the doors that remain open, keep them open, and for those who will be going to HBCUs, ensure that they're able to do so, and that those HBCUs are places of excellence.
That's
Tim,
heavy. I
you're on
see
mute.
Tim was talking.
Yeah,
We need.
Yeah, we're
There
gonna
we
let
go.
him get back.
I'm sorry. I'm so sorry. Is that better? Is that better?
Yeah, go ahead. Yeah. Oh yeah, go ahead.
So to address Dean Ammon's question, and I don't think this is a complete answer to the question, but it is something I've given some thought to. So in addition, of course, we have the 14th Amendment in the federal Constitution, but we live in a system, a legal system governed by a principle of federalism, which means that every state has a constitution, right? So if you
That's
take
right.
Harvard,
That's right.
for example, right, you have the Massachusetts has a provision in its state constitution that corresponds to the Equal Protection Clause. Now, and this is something that has happened in criminal justice over the years, in my years as a public defender, we often pursued this, which is that when the Supreme Court renders an interpretation of a provision of the federal Constitution that is highly restrictive, what you can do as a litigation strategy is, instead of relying on the federal Constitution, you can skillfully litigate a case based on the state constitution, and the state Supreme Court may grant greater protection under its own constitution than what the Supreme Court has decided
That's
to
true.
be appropriate under the federal constitution. So, for example, if you take Harvard, for instance, if there was a litigation strategy in Massachusetts that said, okay, here's what we're going to do. We're going to maintain our policy, and we're going to litigate the case based on the provision of the Massachusetts Constitution, over which the Supreme Court, under the doctrine of adequate and independent state grounds, has no jurisdiction, right? So, in other words, as long as the Massachusetts Supreme Court decided to interpret their equal protection provision in a way that was more beneficial on questions of race, the Supreme Court wouldn't have anything to say about it. And so I don't know how well this strategy would work. You'd have to pursue a litigation strategy like this and sort of evaluate whether or not the state Supreme Court was going to be amenable to it. But that might be one small path forward in light of what we're talking about now.
Yeah, I'd like to go back to something that Dr.
I think you got me
Edmonds.
mute.
Can you hear me?
Yeah, we heard Dr. Foster. Go ahead.
Okay, I'd like to go back to something, Doctor, that you raised regarding surprise. In November of 2022, I began all 4 of my classes telling my students that if they plan to apply to law school or graduate school, that they should do it now, because when they got home in June of 2023, that the U.S. Supreme Court would end affirmative action for graduate schools without a doubt. This is the same court, and I'm just agreeing with what you said, Doc. This is the same court that ended Section 5 of the Voting Rights Act, basically saying that racism was over. So Justice Roberts has a long track record of being against anything that moves Black people into the mainstream. I think he wants to believe that America is, that racism is over. We know that Justice Thomas has a burr in his saddle to deny the vehicle that is responsible for his success. So we're not surprised, but I still think, to your other point, are unprepared to articulate our agenda. What is it that we want to do and can do without the help of the Supreme Court that would move our agenda forward? Or at least what can we do to put this court in a place where they have to speak affirmatively to history? Affirmative action was a soft form, in my mind, a soft form of reparations. But reparations, as we know, is something that can be quantified now. I would be interested to see this court react to a case where a quantified case for reparations was presented to them.
That's something to think about. That's something to think about. Any answer on that? I see a couple questions in the chat real quick. Okay, how will this, RT Richards, how will this impact minoritized people's access to lucrative government contracts and jobs? Or does it affect? Anyone wants to take that question?
In response to that question was answered a long time ago in a case called City of Richmond versus J.A. Croson Construction Company, in which, in a 1989 case, the Supreme Court struck down minority set-asides for government contracts. So they put the death knell to affirmative action. I guess it was, some over 30 years, almost over 30 years ago in 1989. So, yeah, I think that's pretty much been decided already.
All right. I can ask another question, Dr. Woods. You want me to go ahead?
I think Dr. Ammon wants to say something.
Oh, go ahead. I didn't see her hand. Go ahead.
I think you're muted, Dr. Ammons.
She
Dr.
is.
Ammons, you're muted.
We can't hear her.
Me.
There we go.
Oh, there she is. Okay.
Okay, can you hear me now?
Yes.
Can you hear me now?
Yes.
Okay. I just wanted to in a sentence, to respond to the issue of state constitutions. You're right about that in terms of states giving more rights, but here's the problem. Harvard is a private institution. The reason why they're being brought on the carpet anyway is because of the federal monies they received. It'd be a different question if they received no federal monies and they were in a state jurisdiction and the state said, okay, we recognize these things. But as long as they receive federal funds, they are tied to the federal constitution. And that's the dilemma. Not only for Harvard as a private school, but of course all state schools.
Mm-hmm. Right. That's a good point. That's a good point. I think maybe with some creativity, I don't know. I mean, that's a litigation strategy that we would have to think out. But yes, I totally agree with you on that. Yeah.
Here's a question that came up in the chat from Michael Taylor some minutes back. What legal tools are accessible to combat conservative legal activist efforts to challenge race-based admissions practices in a post-affirmative action U.S.? Does Title VI, is his question, offer any recourse? Are there any legal tools that can be used? I know Dr. Golden kind of floated going through the states as a possibility, but are there any legal tools that are accessible. It's right there on the screen to combat some of what we've witnessed over the last couple of days. And does Title VI offer any recourse? Anybody
Well,
want
I'll
to?
answer.
yeah, go ahead.
I'll answer. Can you hear me?
Yeah, we're hearing you, Dr.
Can
Hamilton.
you hear me? Okay. Well, the analysis under Title VI is not going to be any different than the analysis under Title VII, or much different than equal protection, because equal protection applies across the board. 14th Amendment. You can't have a practice under a legislative statute that is contrary to the Constitution. So the real question becomes, in terms of, I don't, in the opinion that was sent out this past week, the majority court, they were all over the place about what kind of remedies. In fact, Borish was one of the ones who reached for stuff that wasn't even being litigated, if you read the opinion, if you remember that. But what folks are going to have to do in terms of legal strategies is to watch in their individual jurisdiction what's going on and what's coming up through the pipeline, and be willing and able to assist. I don't know if that'll help, because one of the statistics I gave you was about the fact that I believe it was Harvard had 24 witnesses, a number of experts, and it's still they still came out on the wrong side of the opinion. So I don't know that the legal strategy at the Supreme Court, we may be in an era that is very similar to the era just Plessy versus Ferguson all over again. I would not even be surprised if they didn't look to see how they could dismantle some of Brown. That's what I would be looking for. That's what I would be focused on. Of course, that's lower education. But in terms of our own strategies, you have to have a multi-approach, a political one. That's why voting is so important. That's why when it comes to seating these justices, we have to be heard. Because it is a political process, even though it's a legal process. The justices that are there on court, nobody will be going anywhere for any time soon. So now it's going to have to revert back to one thing that does work from time to time is when businesses decide to do something. That's not a legal strategy. But when businesses, just like in terms of the gay rights stuff, when they say don't go to Florida, or don't do this, or don't do that, businesses, when they lose money, they pay attention. And that may be one way of looking at trying to find some remedies for our folks, while at the same time, we are open to various avenues to get our people educated.
That's good. That's good. That's good. That's good. Have an economic impact. Go ahead. Go ahead, Dr. Woods.
Do we have any?
Yes.
Did we answer this question here from Linda Carpenter?
No, you can go ahead.
How can Black SDA spiritually and practically tackle these issues, given the divisions within our church and inconsistent GC leadership over the years around the issue of race?
Whew, mercy. Help us, Lord. Go ahead.
Thank you, Dr. Jason.
Dr. Jason, go ahead.
One of the things that we have to embrace, all people that care about the gospel, is that the gospel embraces justice. We have to be clear about that. I just was up there with you, Woods, this past a weekend ago, where we talked about the three angels of social justice. I'll be very brief. In the Old Testament, you had Sadiq, or Sadiqah, which is righteousness. And if righteousness is in the community, Mishpat inherently follows. Then if righteousness is not in the community, Mishpat is corrective. Righteousness is being, Mishpat is doing. We see this in Jesus's life. Jesus says his righteousness is declared by his Father. Righteousness is tested by Satan in the wilderness. And then he declares the mishpat that he will engage in Luke chapter 4. We see the exact same thing with Joseph Bates. Jesus is coming. I'm going to see him. And therefore I must engage in actions of justice. Period. All of the founders were like this. The entire doctrine of righteousness by faith demands that because I am by faith right with God, I must by faith engage in corrective actions around me. And so the three angels' messages have the exact same thing. The first angel deals with your state of being. The third angel, according to Ellen White, deals with righteousness by faith. Bad swing. The second angel addresses the fallen state and actions of Babylon. She's fallen, and she makes all nations drink. The solution is for our community. There is engagement and voting, absolutely. But our communities begin to look within ourselves how we will be righteous and how we will do justice. Those are the two questions for us. If we wait for the GC, they have demonstrated their inability or unwillingness or ineptitude to address justice in practice in the church and in society unless it addressed religious liberty only. If the framework I have just presented is correct, then the church's ability to socially engage and create righteous spaces that engage in corrective justice is a religious liberty right. And if that is true, then it is incumbent upon us to develop whatever it is that we're going to do. And it is incumbent upon us to use Parle to have the state leave us alone.
If I could just follow up on what Dr. Oxford just said, you know, when I was giving my remarks, I noticed Dean Ammons made a very insightful comment in the comments, and I was making the point that God is attentive to history, and Dean Ammons made the point in her comment that God is not only attentive to history, he takes the side of the oppressed. And I think for too long, we have seen God in this neoliberal political conception as a just judge who doesn't take sides. And nothing could be further from the truth. From Genesis to Revelation, we see a God who takes sides. We see a God who, as Dean Ammons insightfully pointed out, is not only attentive to history, but enters into history as an oppressed person, right? He enters into history not as someone who's wealthy, not as someone who has influence or privilege, but he's born in a smelly stable to a teen mother with a bad reputation and no health insurance. That's how he comes to us, right? So God himself is identifying with the cause and the struggle of the oppressed, not because God doesn't love rich people, not because God wants to overlook rich people, but because rich people overlook God. And you can overlook him if you want to, but in the end, God, we do serve a God that does take sides. And I think until we realize that, our spiritual disposition toward issues like this is going to be one of complete incompetence and fumbling, and we'll never get it right. We have a bad habit denominationally as Seventh-day Adventists as waiting for the GC. Oh, what's the word from on high? It's time for local churches to claim their power and to assert themselves as agents that operate, at least from an ideological standpoint and a political standpoint, independent of General Conference directives. If we're waiting around for the GC, you forget that. You're never going to get anything from that level. And the reason why you're not going to get it is to go back to Dr. O'Rourke's presentation, is because the GC and those persons of privilege who hold leadership positions in the world church have an interest in maintaining the status quo in the United States. And so we have to find ways to globalize Adventism at the expense of its historical origins in the middle of a civil war that was being fought over the question of what to do with 3.5 million black slaves. We can globalize Adventism all we want, but the more we talk about its global emphasis, the more we de-emphasize American history, and the more we de-emphasize American history, the easier it is for whites to maintain the status quo. So I say forget about the GC. Local churches have to assert themselves at some point.
And I just want to add also, hearing you all talk, I've been thinking a lot about transitional justice, which, if you're not familiar, it's a process in which a state, like a government entity, will redress human rights or other rights violations through judicial changes or policy reform. And that process doesn't happen at all. And if it happens at all, not well, without first telling the truth. And I think what people of faith should do, Christians should do, is be hard pressed to tell the truth and unearth the lies. It's inherent to what we know as people of faith. Truth telling is essential. I was thinking about what Tim, you were saying about addressing history being key to deliverance. And that's certainly true for Christians. We can't go to God and say, I want to be made whole. I want to be made new. I want a new life, but I'm not going to fess up to anything. I'm not going to confess my sins. I'm not going to, be truthful about who I am. Truth and justice, truth and deliverance, truth and freedom, reparations, those are sequential processes. And so I feel that as people of faith, we should be very stringent on telling the truth. What this opinion did, the opinion we're speaking about, was whitewashing history. It's supported by the backup of, this country, people of this country believing myths and legends about this nation's history in many ways, but especially with regard to race. And so as believers, we should be very honest about where we are in the country and where we've been, and not be ashamed or not forceful in unearthing the truth and the lies. So that's what I was thinking about.
I see.
All right.
I see.
I know
If I might,
yeah, go ahead.
I wanted to add very briefly to that, and I'm in agreement with everything that's been said, that we seem to be hesitant as Adventists to identify the image of the beast. We talk about the beast quite a bit, but the image of the beast, as we know, are apostate Protestants. And now more than ever, the lines need to be connected for our people, because the evangelical Christians who purport to be against abortion or purport to be pro-life are responsible for the assembly of a Supreme Court that is majority Catholic. And that is purposeful. I'm not anti-Catholic, but the religious makeup of the Supreme Court was purposeful to ensure that there would be people that would take down Roe v. Wade, that would take down the walls of separation between church and state. And I think that we've been negligent in educating our people. Most Seventh-day Adventists are of the mind that they're looking for the Pope or the Vatican to do something to us, as opposed to looking at the evangelical Christians so-called evangelical Christians who are working harder than anyone in the Vatican to integrate church and state in the United States.
Yep, that's the image that I was going to ask a question about. But Dr. Ammons, I see your hand, and then Dr. O'Rourke had his hand up.
Yes, three quick things. Number one, in terms of what was just said, that's what happens when you have people in an intellectual ghetto making policy decisions. And until recently, that's what we've had. Number two, that decision is all the more reason why critical race theory must get out and around. Because if they knew anything about it, of course, they don't care anything about it. But if they really purported to know something about the history of Black folks, that particular opinion would look a whole lot different, and critical race theory could help. The last thing is this, more practical, local kind of thing. I'm assuming, and maybe I shouldn't assume, but I'm assuming most of the people on this broadcast are connected to African-American institutions as opposed to majority institutions in terms of SDAs. I would be concerned as a result of this opinion as to what happens to our children who are in majority SDA schools. If the Supreme Court comes down with a decision that says this is wrong, which basically it did, in terms of allowing students to come in. What happened? I don't know what kind of programs they have, for example, at, let me just pick on a school, Loma Linda or Southern or PUC or whatever the other majority schools are. I would be looking to ensure that there is no back retrenchment and backstepping by those institutions in light of this decision, and that we provide some kind of cushion for our students who find themselves there and who are subject to, which I'm sure they will be, kind of the wrath of those who don't think we belong anywhere.
Dean Ammons, if I could just speak to that, I think you raised a compelling point, because at a majority white Adventist institution of higher learning, there's a real struggle, because on one hand, we are trying to jump through hoops to protect our mission and our identity. We try to hide the fact that if you are not Adventist, you're not eligible for tenure. And we want to get preferential treatment despite receiving federal money when it comes to that issue. But I'm curious to see, as you've brought up this issue here on the issue of race, I'm curious to see how quickly admissions people at majority white SDA institutions of higher education will jump to say, oh, well, this is the law. We have to kind of, we get federal money. We have to sort of do this. And it just goes to show you how Black people often end up on the altar of sacrifice when it comes to pragmatic matters. We just become a casualty of a sort of hypocritical white interest in the preservation of a certain Protestant tradition at the expense of racial justice. So it'll be interesting to see how that plays itself out at majority white SDA institutions of higher ed.
Well, ladies and gentlemen, once again, we are happy to have each and every one of you here again. My. Once again, it is so rich, so beneficial with regards to this discussion. As always, people keep asking us, what are the next steps? What are some substantial steps that we can take? And if you can come from your perspective, I don't want to give you some time, but if you can take, as I'm talking, you can gather your thoughts together. If you can give us 3 steps from the perspectives that you've covered tonight about what needs to take place, and make sure that those steps are also inclusive of the audience that is currently listening or may listen in the future to this broadcast. What are 3 steps lay people can take from your perspective to substantive steps to make a difference? We love having these conversations. We love high-fiving each other and saying and quoting, which each person said that was so rich and so profound. But if we can't take action, then this program loses its luster. So once again, if you can share 3 steps, practical steps that anyone who is watching the broadcast can comprehend and implement, because once again, I believe that public affairs and religious liberty ministry is the ministry that will hasten the second coming of Christ. I believe the church does not invest in this ministry. They don't utilize this ministry properly as it relates to evangelism, and they keep trying to refer to it as being politics to hide from what they're actually doing and masquerading injustice. And Ellen White speaks very, very forcibly. And actually, let me just go ahead and read the quote while you're taking the time to gather your thoughts together. I just want to go ahead and read the quote so people can hear it from themselves, what it says. And this is actually not from Ellen White, it's from Elder J. and Andrews. And it says, the sin of slavery is snugly stowed away in a certain package, which is labeled politics. They deny the right of their fellow men to condemn any of the favorite sins which they place in this bundle, and they evidently expect that any parcel bearing this label will pass the judgment of the great day without being examined. Should the all-seeing judge, however, inquire into their connection with this great inequity, referring to slavery, they suppose the following answer will be entirely satisfactory to him. I am not all the censorable for anything said or done by me in behalf of slavery, O Lord. Thou knowest it was a part of my politics. Slavery in the Review and Herald, October 25, 1864, page 172 by Elder J. and Andrews.
Mercy.
Once again, you have three things. And Esquire, Nia Esquire, we want to start with you.
Sure, thank you. And again, thank you for having me here on this panel. I would first, for 3 things, I would first call for universities and colleges to double down on its efforts to make sure that diversity, equity, and inclusion are important. Before this opinion, previous Supreme Court decisions and advocates for race-conscious affirmative action talk about how the benefit for that type of affirmative action is because the schools have an interest of having diverse campuses, and that the students are better off by being exposed to people who are different than them. And so I ask for colleges and universities to double down on its commitments. Many of them have voiced that they are committed to that. And so I hope that they're able to implement policies that reflect that. I also would call on us, everyone, to call on lawmakers and policymakers to enact legislation that would protect the progress we have made with affirmative action, and so that we can continue to be or work toward being a better place, a place that is able to bolster and allow others to achieve and be part of spaces that we would have been historically cut out of. And so that for me is calling on lawmakers and policymakers and being involved in the voting process. And then as a movement lawyer who works with organizers, I ask that you get organized or work with people who are already organized so that that type of advocacy can happen. It's not going to always happen with the law. People who work in law on their own are structurally positioned to maintain the status quo. Often it's more harmful than not. And so if we are getting organized from the ground up, there is a lot of change that can happen. Those are my 3 things that I would suggest.
Thank you so much, Nia Esquire. Appreciate that. Now, folk, you've asked for this in the chat, so take a listen to it and then do something. You know, it always comes up every time we do these broadcasts. What do we do next? Our panelists are sharing it with you, but it is your responsibility to do something with the information that is being shared. Professor Foster.
Yes, again, thank you. I think this time together is ordained. My 3 issues or suggestions are to organize locally and to choose an issue of inequity and to get directly and continuously involved. But the third issue, I think, for the people who are listening to this broadcast is perhaps a little self-serving, but it's something that I believe in to my core. And that is to support the building of a law school and a policy school at Oakwood University. There is no law school in Adventism. I will repeat that. There is no law school in Adventism. If people think that this is law and politics, if you read The Great Controversy, Ellen White says that these movements will take place in legislative halls and courts. Legislative halls and courts. So Oakwood exists to promote social change and the preparation of those who would advance social change. Our department, the History and Political Science Department at Oakwood, exists expressly to protect religious liberty and freedom of conscience. I can think of no better, more targeted investment than to create and build an army at Oakwood University Law and Policy School.
I think that's an excellent suggestion, Preston Foster. How long do you plan to be there so we can make sure it's done right?
It doesn't matter how long I'm there. Nia is ready. Marcia Burden is ready. I can name you a whole cohort of Harvard, Georgetown, American University graduates that are ready now. Should God take my next breath, they're ready.
Well, then the question, Nia Esquire, would you come back and teach at a law school at your alma mater?
I have such great respect for teachers. And I will leave that I have such great respect for teachers. It's a tall order in any context, particularly in a law school context. Yeah.
I appreciate that. But and the reason why I asked you that, Professor Foster, is there's a lot of, as you know, the Oakwood experience is really connected with teachers. And as Nia said so eloquently, there's a lot of respect for teachers, you being one of them, as well as, others who have helped us along the way. But, when people give to schools and ideas, they're really giving to those that they trust. And that's usually the faculty. And though, once again, that's why the interest, my question came to you with regards to, you being there, because that is something that you have obviously established a credibility with your students, but also your peers who you went to Oakwood with, where they would be willing to support something like that, knowing that you were at the helm or were somewhere, as a part of that.
Well, that's nice of you to say. And my youngest daughter is 15. And so I am committed to Oakwood at least until she graduates, if that gives you any sense of how long I plan to stay, God willing.
Well, ladies and gentlemen, we have an answer there. So, and we're going to do this. We got to get moving. Thank you so much, Professor Foster. I greatly appreciate that. Dr. Linda Ammons.
All right. Can you hear me there? We had some problems earlier.
Ma'am.
Yeah, we're good.
Okay, so here are mine. First of all, call a lie a lie. Preach it and correct the record. And that means whether it's in the church pew, whether it's at your conference office, whether it's at the main GC or whatever it is, call it what it is. Jesus never backed up on calling whatever it was what it is. Number two, make coalitions with like-minded people who are not a part of our clan. We need to be visible on social justice issues, and this is just one of them. But that's something that we can do, and I think someone else made reference to that. Number three, I say this kind of tongue-in-cheek, but I'm kind of serious about it. If you're a diversity officer, you might want to begin to expand your portfolio depending upon where you are. not only in schools, but in other places where now that this decision comes out, and it will have a full effect, I promise you that, where people have just given lip service to diversity, they may decide that we no longer need those kinds of people. So just watch your back. Number 4, look to see in these organizations who the diversity officer answers to. That will tell you a lot about the power that that person actually has. If the person answers to a low-ranking HR person, they have no power. But if the person answers to, in a school setting, the provost or the president or something like that, then depending upon the president or provost, that person has the ability to get something done. Number 4, check to see now what the boards of trustees are saying about this opinion. That will tell you something about what the schools are likely to do, because the board of trustees run these schools. And if they are, a lot of people are going to be confused at this point, and in the admission, I feel sorry for the admissions people, because school will soon start, and I know that they are just they probably don't know what to do. But check to see what the boards of trustees are saying about this opinion, and if it isn't compatible with what you believe, then you may want to think 2 or 3 times about sending your children where to those places. And lastly, watch, pray, and act. That's it.
Thank you so much, Dr. Ammons. Dr. Jason O'Rourke.
Dr. Jason, you hearing us? I don't know if he's hearing us.
I got you.
You got us?
hear me?
All right, go ahead, man. Yeah, we're hearing you now. We're hearing you
All
now.
right.
Waiting on your 3.
All right. Firstly, and I'll probably get in trouble for this. Embrace biblical Adventism, if you will, and reject white supremacist Adventism. That's one. I'll leave that there, but I'm just going to say that right there, because the way we have interpreted Revelation 13 is white supremacy, period. The way we applied it in the 20th century is white supremacy. It's time to embrace what the Bible's actually saying and become relationally relevant to the community that we're in. Instead of, and that's my second point, become community facing and people centered. Become community facing and people centered. We have a lot of talking heads. We have a lot of insular conversations about things that do not affect the greater community at large. And you can see it in the locations where our churches are and the numbers. Become community centered, community facing, and people centered. And lastly, I would say support your regional conference and church. And with that, I would say, do not think that you're going to apply this colonially. What is good for Detroit may not be good for Kansas. Okay? The principles apply, the application can be flexible. So regional applications, support your local regional conference, church, regional institutions, and understand that the way you're relevant in Tennessee may not be the way you're relevant in California.
I was going to ask you to say that again, but you said it again. So look at God. That was good.
I just want to say one thing, just the last thing, and I've said it. I want to say it again because we need to think about this. Ellen White has a quote that was on the screen that she said in 1907, and I quote, this is why this is important. There will be slavery again, as certainly as it has been in this country, and this time on better terms, people. The GC state conferences, state institutions, and their schools are not having and are not willing to have this conversation. This now becomes an internal conversation among ourselves. Which conference is safe? Which is safe? Which hospital is safe? Which school is safe? This is the catalyst behind my suggestions.
Received. Received. All right, Dr. Woods, who's up next?
Last but not least, Dr. Timothy Golden.
All right. Thank you, Elder Woods, and thank you, Elder Josiah. Thank you to all my fellow panelists. I've been honored and privileged to be here with all of you, and it's just such a joy to learn so much from all of you. This has been a very enriching discussion for me. Number one, you have to vote. President Trump put 3 Supreme Court justices on the court in 4 years. That is extraordinary. You have to vote, and you have to, if for anybody who thinks presidential elections don't matter, if Hillary Clinton had, and I'm not trying to extol the virtues of Hillary Clinton, so don't come at me with this, oh, Hillary Clinton. Listen, whatever you think about her, if she had won in 2016, we would be having a very different conversation right now.
That's right.
Because she would have had the opportunity to put 3 justices on the Supreme Court in 4 years. Okay? So, number one, you have to vote. Number two, as Seventh-day Adventists, we have to get out of this idea that constitutional rights are subject to some sort of hierarchy and that they're somehow severable. For decades, the Seventh-day Adventist Church remained silent on issues of criminal justice and mass incarceration, as the Supreme Court did to the Fourth Amendment, what they've just now caught up to doing in the 14th Amendment, and the church never said a word about it. I've become a small part of an Adventist organization of lawyers who's trying to do some things to help law students. And we are still, even among legal circles in the church, teaching this false idea that if you're a criminal defense lawyer, you somehow have an ethical or moral dilemma as a Christian. My goodness, I wish we could get beyond that false kind of thinking. And I wish we could stop it with the doctrine worship, because that's what we do. We're so preoccupied in vindicating what we believe as though our beliefs alone are going to save us. And they're not. I can't put it any better than Dr. O'Rourke just put it. You can't be doctrine centered. You got to be people centered. And so number two is you got to understand that every decision of the Supreme Court matters, not just the ones that affect your right to Sabbath observance. That if there's a decision that somehow eviscerates the Fourth Amendment, where a young black man or a young black girl is now all of a sudden subject to racial profiling, that's a decision that ought to matter to the church. That decision matters just as much as this one or any other court decision. So we have to understand, number two, that the Constitution is non-severable. And number three, our allergy to people outside the church has got to be overcome. Seventh-day Adventists are frankly not known for their activism. So if there are people, and Dr. O'Rourke said it nicely, if you live in an urban center like New York, Chicago, Los Angeles, Philadelphia, Detroit, Atlanta, wherever, there are community groups who are already engaged in the kind of work that we're just trying to dip our toe into, right? They've been doing the work for years. It's time for us to be members of those grassroots community organizations and ask ourselves hard questions like, how can I get involved with these organizations without trying to save people and pass out tracts? That has to stop. We have to get past that, and we have to understand that we are part of a larger community of Black people. We are so caught up in the SDA part of our Black SDA identity that it prevents any meaningful sort of solidarity with other Black people who don't believe what we believe. So what, they don't believe what we believe. That's what makes the world go round. But it doesn't matter if you're in the church or not. If you get stopped by the police, or if you were denied an opportunity at a higher education, or whatever the case may be, it doesn't matter whether you're Adventist or non-Adventist. I was Black long before I was an Adventist. And the sooner we realize that our racial identity is at least as important, if not in many instances, more practically significant than our theological identity, then we can get somewhere. So vote. Number one. Number two, the Constitution is non-severable. And number three, involve yourself with people who are already doing the work without, and leave and check your theological supremacy at the door. So those are my three recommendations.
Well, I think once again, truth to power has been spoken. And, we've talked and we've heard a lot of things. I do want to attribute what Nick Millard shared on the conversation that took place last night in cooperation with Washington Adventist University and Liberty Magazine, a very thought-provoking conversation that dealt with the Supreme Court decisions, because sometimes we forget that there are a few minority voices among the majority that are speaking truth to power, that are making sure that their voices are heard. And I can honestly tell you, in the 15 years of work of Sparrow and Lake Region, it's even true in Lake Union, because I'm still astonished how the birthplace of Adventism has gotten so far away from its pioneers. But it's nice to know that there are a few people who have spoken up. And I would be remiss if I didn't, acknowledge the few that have. Although it's not the majority, although it's not making a difference as it relates to these conversations with the leadership at these respective institutions, I would be remiss if I didn't acknowledge the few that are speaking up in terms of that, and at great peril, by being called Negro lovers and everything else. They're willing to continue to speak truth to power and practically applying the gospel of Jesus Christ, not just in rhetoric, but through action and standing up and being counted.
Man, I just want to real quick, Elder Woods, man. So, as a regional conference executive secretary, I believe in note taking, and I know we have 5 panelists, but I got 16 points. And I'm willing to write this out, man, and make this some kind of a I don't know, practicum, next steps. If somebody missed it, I'll find a way to write this out, man, and get the word out with all that has been shared.
Well, if you want to share a few of those for the people, go ahead. They're just a few.
From the beginning, just a few. Double down.
Them all, run them through. We can. If you could do it succinctly, go ahead.
I think I can. Let me try it. Number one, double down if you've got a diversity, equity, and inclusion person at your institution. Call your lawmaker. Number two, call lawmakers and policymakers at your local level. Number three, work with organizers at the local church. Number four, choose an equity and my handwriting is that bad, but I'll figure it out. Support the building of a law school. That was policy. Support the building of a law school, law and policy school at Oakwood University. Dr. Preston, I got it. Number six, call a lie a lie. That's an easy one. Everybody should get an A on that one. Call a lie a lie. Make coalitions with other peoples of other faiths. Whoever does the DEI, who does the DEI representative answer to? That was a question. That's for some of you to do your research. Whoever they answer to, that tells you about their power. What are the Board of Trustees saying after this decision? Watch, pray, and act. Number 11, embrace biblical Adventism and reject racist Adventism. That's just my straight way of saying what Dr. O'Rourke said. be community facing and people centered people. Support your regional conference and churches. Vote. Another easy one. Vote, y'all. I don't care what the politics says. I don't care what what the pressures that you get and all of the political spinning that you hear out there. Vote. Elections have consequences. Every decision at the Supreme Court matters. Every decision matters. Things that affect us as a people, not just ones that affect religious liberty. Number 16, we got to get over our allergy to people outside the church, and become friends with each and every person that's out there. That's it in a nutshell. But I definitely will type it up and make it look good, and probably add it to some of the chats that's already taking place.
Well, if you can put it on the Conscience and Justice Council Facebook page, Pastor
That's
Josiah,
good.
as a post, we'll put it on the Conscience and Justice Council Facebook page. And also, a shameful plug, but like us on Facebook and subscribe to us on YouTube so that you can get the latest information. We pride ourselves on being trustworthy, relevant, and stellar content. And as you can see from our panelists this evening, our tradition has continued under the fresh baptism of the Holy Ghost. And once again, we appreciate that. We appreciate that so well. I do want to acknowledge not only the show that took place last night, but also the Second Chance broadcast that will take place tomorrow, that will also feature Preston Foster and our good brother, Kenny Anderson, whose comment is up on the screen. Preston, can you share what time it will air so people can access the program tomorrow?
It airs from 2 to 4 p.m. Central Time, 2 to 4 p.m. Central on WOCG.
And they can
WJOU. I'm a little dated.
Yeah.
WJOU.
All right.
Thank you. 90.1 FM.
All right. We're going to have some closing remarks before we have closing prayer. And we definitely want to have our panelists. So we'll put them in the background so we can thank them for the stellar job once again that they have done with us today. We're grateful to have them. Thank you once again. Pastor Josiah, we have, and I want to put it on the screen so that we can share what we have coming up next. What we have coming up next is our Conscience and Justice Council. Our Conscience and Justice Council will take place September 28th to October 1st at the North American Division of Seventh-day Adventist headquarters. Once again, our Conscience and Justice Council will take place at the North American Division of Seventh-day Adventist headquarters, September 28th to October 1st. Here's a first wave, I repeat, a first wave of our keynote speakers featuring Bishop Vashti McKenzie of the National Council of Churches, President and General Secretary, the first ever African-American female lead of the African Methodist Episcopal Church. You want to hear this dynamic woman of God as she speaks for us on Friday night. Dr. Barbara Williams Skinner, CEO and co-founder of the Skinner Leadership Institute, who works with community engagement. She'll be doing a general session and a workshop targeted to pastors and elders, at the convention. And then last but not least, Dr. Paula Olivier, Youth and Young Adult Director, will be the Divine Worship Hour speaker at the convention. Once again, all roads lead to North American Division headquarters for the annual Conscience and Justice Council convention. You can register today at www.cjcouncil.org. Click on the registration link. When you click on the registration link, not only can you register for the convention, but you can also secure your hotel at the discounted rate. Registration is $199. You want to register early before the price increases. Once again, we have a limited amount of seating. Once we reach capacity, we will close out registration. So we encourage you to register today. Not tomorrow, but today for the Conscience and Justice Council. You'll be intrigued by the topics. We'll be dealing with redistricting and voting rights, the three-legged stool of democracy being redistricting, voting, and census and how important those are. We have some top-notch lawyers coming in for those presentations. We have a track on liberty, a track on justice, a pastor's track, and also a Hispanic track. There will be translation services available for those who speak Spanish to be a part of this convention. So once again, the NAICS, Conscience and Justice Council Convention, will take place September 28th to October 1st in Columbia, Maryland, at the North American Division headquarters. Pastor CJ.
Yeah, man. Listen, I see Kenny Anderson's comment in the chat. He said that's a strong lineup. I'm gonna tell you what, y'all. This is indeed a strong lineup. This is a strong lineup, and we believe that even if you are, well, number one, if you're in the DMV, come on through. You know, we've tried to go around the country and kind of share the wealth on this training and this kind of information. And so this is we were in New York some years ago, but this is our second time back to the East Coast. We were in California last year. We were in Atlanta. We were in Houston. But man, listen, man, we need our DMV family to come through on this. And if you're like me and you've got family there, I'm in the Kansas City area. If you don't want to stay in the hotel and you want to save some money, just hook up with one of your friends or family, or even if it's your Adventist family in the DMV area. It's right there, hosted by the North American Division headquarters, and it will be a phenomenal conference. And so we're looking for pastors, our Hispanic brothers and sisters, everybody that's interested in issues of conscience and justice to come on out. It's going to be phenomenal. It's going to be phenomenal.
Once again, this has been CJC Today with your co-hosts, Christian Josiah and Edward Woods III. We would like to thank our distinguished panelists once again for being a part with us today. Dr. Timothy Golden, Nia Langley Esquire, Dr. Linda L. Ammons, Preston Foster, the professor, and Dr. Jason O'Rourke. We look forward, I repeat, we look forward to engaging you the next time something pops up and bringing fresh content, stellar presenters, and speaking truth to power, because we want to be ready when Christ comes. Let us not be holding back to fulfill the great gospel commission. Let's not hold back our desire to see Christ's face in peace, because we exercise privilege over being a representative of Jesus Christ. Thank you so much. God bless you, and have a good evening.
Amen.